Hello friends, in the series on the income tax cases, today we will discuss the case of KAVERI Infrastructure Private Limited versus Commissioner of Income Tax and others. This case has been reported in 455 ITR at page number 384 and the matter has been decided by Punjab and Haryana High Court and the date of the judgment is 15th February 2023. This case is regarding section 147 and 148 assessment. In this case, the assessing officer was doing the assessment of assessment year 12-13 and it was the finding of the learned assessing officer that the assessee is involved in works contract and not in infrastructure development, and the assessee should not get 80 IA deduction which is regarding infrastructure development. Accordingly, assessing officer issued notice under section 148 for the 4 years for assessment year 8-9, 9-10, 10-11 and 11-12, and it was the allegation of the assessing officer that there is failure on the part of the assessee to disclose all the things which were necessary for completing the assessment at that time, and the assessee has hid with the department that the assessee was not doing the infrastructure development activity but he was involved in the works contract activity. So the assessing officer reopened the assessment under section 148. As all we know that if the assessing officer has to travel beyond 4 years for reopening under section 148 in the old regime and the assessing officer has completed the assessment under section 143 subsection 3 for those earlier years, then there is a proviso of section 147 which says that the assessing officer has to demonstrate that there was a failure on the part of the assessee to make true and full disclosure about the escaped income. When the assessee received the notices for the 4 years, the assessee preferred a writ petition in the Punjab and Haryana High Court on the point that in this case, this is a case of change of opinion and there is no failure on the part of the assessee to disclose true and full information about the assessee income. It was the point of the Punjab and Haryana High Court in the writ petition that it is the primary and basic duty of the assessee to disclose only the primary facts at the time of the assessment, and it is the assessing officer who has to make the inquiries and draw the inferences. If the assessing officer is not able to draw the correct inferences, then it cannot mean in the future years, and the assessing officer cannot allege on the assessee because of his fault for drawing wrong conclusions that the assessee has not made true and full disclosure. Further, the High Court was of the opinion that there was no subsequent information, there was nothing new, and the assessing officer was reopening the assessment on the basis of the same documents which were available with the assessing officer at the time of the original assessment under section 143 subsection 3. The court said that if there is a failure on the part of the assessing officer during the original assessment, then it cannot become a basis for reopening in the future years the assessment of the same years, because in that case it will be termed as change of opinion and not income escaping assessment. The court further said that if anything comes new with the assessing officer, then it is the duty of the assessing officer to demonstrate the live link between the new material which have come to the knowledge of the assessing officer and between the income escaping assessment. So the proviso to section 147 gives a shield to the assessee about arbitrary reopenings by the department beyond 4 years where already the assessment has been done, because if it will be done in the garb of review or in the garb of change in opinion, then there will be a very anxious position for the assessee and there will be no end of litigation and there will be no end to the concluded assessments which have taken place. So in this case, the High Court quashed the notices under section 148 on the plea that these were the clear case of change of opinion. At the end of this video, once again, I am repeating the name of the case. The name of the case is KAVERI Infrastructure Private Limited versus Commissioner of Income Tax and others, and this case has been reported in 455 ITR at page number 384, and the matter has been decided by Punjab and Haryana High Court, and the date of the judgment is 15th February 2023. Thank you, friends.